And a good morning it is. The clouds have all cleared and the sun is shining brightly on Mississauga. I'm Elizabeth McIntyre. I'm here with my partner Freya Christensen and the star of the day, Mayor McCallion. Mayor McCallion has a short statement to make to you, and she will then take some questions.
Those two standing there remind me of June 1st, 2009, when they were with Peter.
If you have any. So I'm going to turn it over to the mayor.
Well, welcome everybody. It's great to see the attendance. I always appreciate the presence of the press on special announcements, etc. So welcome to City Hall. Well, I'm very pleased with the decision released today. Justice Broke found that I was not in a conflict of interest regarding Peel Regional votes on the 2-7 development charges filed. The municipal conflict of interest application has been dismissed in its entirety. I'm glad that the lawsuit is over, even though it has not affected my work on behalf of the people of Mississauga. But needless to say, it's good to know it's done, and we're on with the many challenges that Mississauga faces. Judge Prout found that reasonable electors would conclude that I demonstrated greater concern for the public's interest than for my son's interest. In fact, he recognized that on my insistence with owners that a hotel be built first to further Mississauga's dream of a hotel convention center caused the project to fail. The judge also concluded that my son's interest would not have influenced my vote. It's important for the citizens of Mississauga to understand that I have always put their interests first. Well, I'm happy that the application has been dismissed 6 years after the votes. It leaves me with concern about future people who offer themselves for public office. The case has cost me personally $500,000 in legal costs. There is $50,000 insurance at the Region Appeal, and that's the only coverage that I have. Anybody can bring an application at any time within 6 years, exposing politicians to all exorbitant costs. There have been a number of recommendations over the years to examine and amend the Conflict of Interest Act, including most recently by Commissioner Cunningham. This case demonstrates the need for legislative reform as soon as possible. I will urge the province, and especially the new Premier, Kathleen Wynne, who I have great respect for, to urge her to get on with the review of the Conflict of Interest Act. We need to continue to have good candidates at the municipal level, and this act is certainly not helping. In the judge's opinion, so, ladies and gentlemen, press, I'm open for questions from you in regard to the issue. I think
Elias Heslin's lawyer, I just spoke with him, and I understand that they're not happy with the ruling, and they're just going to be going over, all of the paperwork, all the information, and they say that at this point they're not sure, but that they're looking to see if there's grounds for an appeal. What's your response to that?
Well, I can respond to that. That doesn't surprise me, A, that they're not happy with the decision, and I assume they will be looking at it for grounds of appeal. We certainly will not be seeking to judicially review it. If they file an application, then we will of course deal with it in due course. We haven't had any conversation with them, don't know what their grounds would be, but we'll respond as appropriate.
Madam Mayor, the judge found that you were willfully blind and also that you knew that your son owned WCD. Do you have any regrets, or will you change the way you do business in the city?
What is your question?
Do you have any regrets? Any regrets about what happened, the way you vote, or will you change the way you do business in the city?
No, I have no regrets in regard to the issue, because I think where the judges said, made some statements, I understand that from his review and research he did, etc., he has made certain statements, especially regarding finding the mayor knew of Peter's interest. I did not know of Peter's interest, and therefore, that's it.
Madam Mayor, what do you have to say about the judge's finding that you were willfully blind to the to your son's hotel deal? I mean, do you have a comment on that? He certainly was clear in making that statement in the ruling.
Okay, in the judge's opinion, as I understand it, and I haven't been able to read the entire document, we just got it. He thought I should have made more inquiries about the status of the project. Well, in order to do that, the reason I did not make inquiries about the status of the project, because any discussion that I would have with staff could be influencing them in some way or other. The fact that we were discussing the item. So I wanted to stay away from it completely, waiting until it came to council, or a committee of council, to the planning committee, or to the council itself, which the Conflict of Interest Act clearly states you must declare a conflict if you have one. So that's why I did not respond, I did not check on it. And in regard to the way we operate, we're not aware of site plan applications, we're not aware of building permit applications. That is, I have no idea as of today how many applications have come in for site plans or for building permits, nor does any member of council know. Unless they make a point of somebody discussing it with them. Otherwise, we don't get a list and such. So therefore, I wanted to stay away from it by not discussing it with staff. Or staff briefing on it, because if any discussion that would take place, that could indicate that there was input.
Mayor McCallion, you stated that this term in office will be your last.
Yes.
You've told me that, you said it fairly publicly. With this decision, and obviously tons of support for you in Mississauga, do you think you might change your mind on that?
No. When I tell the public I'm going to do something, I think I've always done it. And therefore I told the public after the last election that I would not be seeking re-election after this. And therefore, that's it.
I've asked her if she'll run for mayor of the city of Toronto. And she's given me the same answer.
Mayor McCallion, have you ever had any direct corporation dealings with your son?
Pardon?
Have you ever had any direct corporation dealings with your son?
Direct contract?
Corporation dealings.
No.
Wrong answer.
No.
Will you be seeking to recoup any of your legal costs, the $500,000 in legal fees?
Well, the general rule in these kinds of court actions is that the loser, Mr. Hazenet, pays the winner's costs. So I assume that we will be making the appropriate application, at least some of the costs. Unfortunately, because of the dimensions of this, it was very costly. There were 13 out of court application or out of court cross-examinations of witnesses. There was a 2-week trial. It was a very costly application because of the way it was designed by the applicants. So of course we will be seeking to have a cost order made in Mayor McCallion's favor.
Sorry, Ms. McIntyre, could you just clarify, so the overall legal fees for Mayor McCallion's defense was $500,000?
And we should clarify, actually, because that also includes all the legal disbursements. So when we say the judge said there's 5,000 documents that he read and 2,500 pages of transcripts, all of the court reporters' charges and everything else goes into that. But yeah, a very complex case like this with 13 out-of-court examinations and a 2-week trial, $500,000, I'll tell you, is a pretty good deal. It sounds like a lot, but it's a lot of time.
There was also motions around things like the applicant tried to rely on the testimony from the inquiry, that sort of thing. So there were a number of...
Sorry, I just got two things, just follow up on that. So the city, under its insurance policy, went up, it can cover, is that correct, up to 50,000, is that correct?
The regional insurance policy, because this was a regional vote, the region has insurance, the limits of which are $50,000, which is inadequate in today's environment for any municipal politician. So part of what the mayor and we have talked about is that all municipalities should be looking at the reasonableness of insurance coverage for elected politicians.
Are you worried?
Otherwise, you're going to discourage people from offering themselves for office because their total assets are up for grabs with some political motivation.
That's actually exactly what I was just going to ask. Are you worried that this could now kind of snowball and open up the floodgates for other suits to come forward?
I don't follow the question. What is the question?
Do you mean with respect to Mayor McCallion specifically?
Yes.
Or do you mean generally?
No, to Mayor McCallion.
I don't think so. Part of the message from this case is that he didn't win. He lost the conflict of interest. The judge found he was beyond the limitation period and he shouldn't have brought it. Now this, Mr. Hazené is exposed to a very large costs award. So, Mayor McCallion won this case and she won it big time. So it's not a good tool though for investigating issues at the municipal level because of the cost.
But the concern generally for municipal politicians is that there may be people out there who want to bring these applications for political purposes. Because as you know, there's no discretion in the judge if they do find a conflict. The result is an automatic removal of the politician from their office. So the risk is that applicants will use it for political purposes.
Mayor McCallion, you mentioned just moments ago that you said that you hope that individuals who have political motives, won't come forward and run in Mississauga. During the hearings, or that this would certainly send a signal to not come forward if you've got political motives. During the hearings, it was suggested that Mr. Hazené was a quote-unquote straw man, and that a particular individual, former Councillor Carolyn Parrish, that he was connected to, might have been behind a lot of this. Can we just speak directly to that on the issue of Ms. Parrish?
Yeah, well, let me quote the judge.
Yeah.
The judge understood what was going on. He found that Mr. Hazené and Carolyn Parrish couldn't be much closer. She provided evidence, affidavits, and documents, and there's evidence she made a final contribution to Mr. Hazené's lawsuit. And I believe she attended every session, according to my lawyer, she was present at every session that occurred on the issue.
Madam Mayor, could you clarify about political purposes? I mean, after all, the regular people don't have the deep pockets to deal with these things. The government won't deal with it. So basically, it's the politicians policing the politicians. So when you say it's bad for something to come forward for political reasons, could you really explain that, since nobody else but politicians know what's going on?
Well, I think the Conflict of Interest Act should be revised for one thing with many points of view, because the interpretation of it is all over the map. Let's put it this way, the Conflict of Interest Act has been used, and I know of many examples across the province, and it strictly is used mainly for political reasons. That seems to be the research that's been done. I don't have all that data available anymore.
Can you clarify what political reasons are?
Political reasons?
Yes.
I don't know, I guess. Political reasons is challenging somebody for a position, or especially defeated politicians. Usually it's defeated politicians.
Okay.
Madam
I
Mayor,
think that's usually defeated politicians.
Madam Mayor, I'm not sure if this is a question for you, or maybe it's for Liz and Freya, I'm not sure, but what do you say to people who say that you won this case today based on essentially two technicalities, one of which is that the site plan was deemed incomplete, and the second of which was that that Elias filed the application too late. Is the vindication still the same, or can either three of you respond to that, that some would say it was two technicalities that allowed you to be vindicated today?
I don't consider them technicalities at all. I mean, the basic question is, was the matter, did a matter on which someone had a conflict come before council on which you voted? That's the fundamental question. It's not a technical question. So what the judge found was that WCD didn't have a matter that could have been affected by the red circling of development fees. That was the fundamental question. It wasn't a technicality. And he also found that there were three reasons that he dismissed the application. That was one of them. And that's the first question. Is there a conflict of interest? Is there a matter on which there's a conflict? The answer is no. The second reason is he said it was too remote. And his finding was, and that's based on his finding that a reasonable elector would consider that Mayor McCallion had demonstrated greater concern for the public interest than Peter's interest. And he refers to what Mayor McCallion talked about, the fact that it was her insistence with Omer's that a hotel be built before the condominiums. And if Peter were to have benefited, it would be for the condominiums. So he makes that finding. And he says, in my opinion, a reasonable elector apprised of all the circumstances as of the votes would not regard the deemed financial interest as likely to have influenced her vote. That's the very crux of a conflict of interest. That because of a conflict, it influences your vote. So that's not a technicality. Those are two fundamental issues. And in terms of the time limitation, I don't know that that's a technicality either. I mean, that's put in the legislation for a very good reason. So that would be my answer to your question.
Sorry, last question, just to go back to something that you addressed earlier. The judicial inquiry, the Mississauga judicial inquiry, the findings of Justice Cunningham, he made it pretty clear that, as you've just said, that the MCIA is pretty much completely flawed, or very, very seriously flawed. And he put forward a lot of recommendations. You know, and Mayor, I don't know if you've addressed this publicly before. I know what you just said now about Premier Wynne, but can you tell me, how disappointed are you that a $7 million inquiry, and now another case, the stuff that Mayor Ford went through, where pretty much every municipal lawyer in the province said you've got a blunt instrument, removal from office, if it's not inadvertent. What are you going to do to say to the province, you know what, put the findings of the inquiry at the top of, maybe not ahead of the big move, but pretty high up on your agenda?
Yeah, well, I have a lot of confidence in Premier Wynne. I think that since she's been elected Premier, I can assure you that she's changed, or she's gotten involved in many issues and has had them settled. And I think that I will be approaching her definitely, and I feel that she will be concerned and take the necessary action. I really do. I think the time has come. I don't think we can allow this to go on, that an act can be used politically to attain an objective, etc. I think it's got to be clearly defined as to the involvement of the elected person in regard to the business of the city. I mean, it's going to cause, in my opinion, people, as I say, unless the city or unless the municipality has protection. Directors now of companies have protection. I'm a director of Eversource, and so is Councilor Mahoney. We have protection. We don't have any protection as a mayor or city councilors in the city of Mississauga. And the region, I mean, it's $50,000 for a case that is just may run over $500,000 that I have absolutely no coverage other than the $50,000. So, and I think in discussion with lawyers, etc., my own as well, my own two very capable lawyers that handled this case, handled the inquiry as well, did an excellent job. Just delighted with their professionalism, their research, the way they handled themselves in court, etc. Anytime they appeared, I felt proud of representing them. It's serious, very, very serious. And I now have politicians talking to me about it in other areas, saying, you know, we didn't realize that our neck is out unless there's coverage. So to protect, for political reasons, people are taking action. Thank you very much for coming, and as I say, I want to thank my two lawyers. They did a fantastic job, and I have not allowed this to interfere in pursuing all the many challenges that we have as a city, and promoting the fact that in the Greater Toronto area, I'm working hard to make sure we solve the problems of the terrible mess that we have as congestion in the GTA. And I will continue on until I end my term as of 2/14. It's been just a joy to be the mayor of Mississauga and to have some excellent councillors over the years that have served with me and given their best to the people. The press is a little rough, etc., and especially the local press. But, you know, I'm sure that maybe at the Mississauga News they'll be lowering the flag in sympathy.
Well, this is my backyard. It's my back gate.
Take care of it.
I hate to start
Come
my
on out to Mississauga
politics
anytime.
Here's the pot of
I
coffee.
still want to meet with you on Sunday.
Ain't that pretty? That ain't the best part, baby. Just wait. It's a genuine weather vane that moves with the breeze. Portable hammock, honey. Who needs trees? It's a casual entertainment. We aim to please. And my party's alright. Check out the shingles. It's brand new. Excuse me while I mingle. Hi, how are you? Hey everybody, let me give you a toast. This one's for me, the host with the most. Yeah. It's getting a trifle colder. Step inside my home. That's a brass toilet tissue holder with its own telephone. That's a musical doorbell. It don't ring. I ain't kidding. Plays America the Beautiful and Tyler. Boy, this punch is a trip. It's okay in my